Selamat pagi juga kami ucapkan kepada Bapak Ibu yang telah bergabung bersama kami secara online. Acara akan segera kita mulai. Untuk itu kami mohon perkenan Bapak Ibu untuk mengaktifkan fitur video yang ada pada layar laptop Bapak Ibu dan juga menonaktifkan fitur mikrofon pada laptop Bapak Ibu demi kenyamanan kelangsungan acara pada pagi hari ini. Terima kasih. Baik, Bapak Ibu izin seminar akan segera kita mulai. Good morning, may I have your attention please? We would like to invite all of the participants in this international seminar to enter the room and please take your seat. And we would kindly advise all distinguished guests and participants in this international seminar to switch the mobile phone into silent mode or vibrant mode to avoid any interruptions during this seminar. Thank you.
Om Swastiastu.
His Excellency Dean of the Faculty of Law, Udayana University, in this occasion is represented by Vice Dean 1 for Academic and Planning Affairs, Profesor Dr. Desa Putu Dewi Kasih SH Hum. The Honorable Vice Dean 2 of Finance and General Affairs, Vice Dean 3 of Student and Information Affairs, Coordinator of Master of Law Program as the host of today's event, and all study program coordinators at the Faculty of Law of Udayana University. Our speakers for today, Fato Selita, Barrister of England and Wales and Attorney of the State of New York, Professor Yulia Kovas, PhD, Professor of Genetics and Psychology at Goldsmiths, Visiting Professor at New York University in London, Bapak Igusti Ngurah Parikesit Widya Teja SHM Hum LLM PhD, Lecturer at the Faculty of Law Udayana University, Bapak J. Maulana, Student of Master of Law Program at the Faculty of Law Udayana University, Moderator and all participants, ladies and gentlemen. Praise and gratitude to God Almighty, because of His blessings and grace, we can all gather on today, Friday, 14 April 2023 at the Faculty of Law Hall, Udayana University, Bali, for the opening ceremony of the International Seminar on Interdisciplinary Approaches in Legal Studies. This seminar is organized by the Master of Law Program of Faculty of Law, Udayana University. Before we enter into our main agenda for today, we would like to invite all audience to sing the national anthem of Indonesia, Indonesia Raya. Therefore, to all audience to please stand up, and for the committee to please come to the stage. Thank you. Thank you. To all the audience, to please remain stand up as we are going to continue with prayer. I invite all audience to pray according to your respective beliefs. Thank you. Prayer is started. Prayer is finished. For the audience, you may please be seated. Thank you. Excellencies, distinguished guest participants, ladies and gentlemen, the next agenda is welcome remarks by the committee chairman. Therefore, we would like to invite Dr. Igede Pasek Eka Wisanjaya SHMH to come to the stage. To Bapak Dr. Pasek, time and place are yours. Thank you.
Om Swastiastu. Assalamualaikum warahmatullahi wabarakatuh. Salam Namo Buddhaya. Salam kebajikan. Selamat pagi. Salam sejahtera selalu. Good morning, ladies and gentlemen. Your Excellency, Vice Dean for Academic Planning and Corporation Affairs of the Faculty of Law, Udayana University, Honorable Coordinator of the Master of Law Study Program, Faculty of Law, Udayana University, Heads of Laboratories and Heads of Units within the Faculty of Law, Udayana University, speakers, moderators, organizers, and participants. First of all, we welcome you to International Seminar on Interdisciplinary Approach in Legal Studies, organized by the Law Master of Law Program of the Faculty of Law, University of Udayana, today, Friday, April 14, 2020. Praise be to the Sang Yang Widya God of Almighty, and enably this activity can be held because of His grace. On this occasion, allow me to represent the organizing committee to deliver the committee's report. This seminar aims to explore, identify, and discuss interdisciplinary approaches in legal studies. Please also allow me to inform you that this seminar presented 4 speakers, namely, number 1, Fatos Selita, LLB, Barrister of England and Wales, and Attorney of the States of New York. Number 2, Professor Luya Kovas, PhD, Professor of Genetics and Psychology at Goldsmiths, visiting professor at New York University in London. Number 3, Gusti Ngurah Parikesit Widya Teja, SIM Home LLM PhD, lecturer at Faculty of Law, Udayana University. Number 4, J. Maulana SH, student in Master of Law Program, Faculty of Law, Udayana University. As the moderator, Imade Budi Arsika, SH LLM, a lecturer at the Faculty of Law at Udayana University. The audience who attend this seminar are lecturers and law students at the undergraduate, master, and doctoral levels of the Faculty of Law, Udayana University, students from study programs and international programs at Udayana University, Master of Law students of other universities in Bali. In addition, some participants attended this seminar online through Cisco WebEx, especially those outside Bali, and we hope that this seminar will benefit all parties. Finally, can allow me to invite the Vice Dean for Academics Planning and Corporation Affairs of the Faculty of Law, Udayana University, to deliver a speech and officially open the seminar. Thank you very much. Chairman of the committee, Dr. Igede Pasek Eka Sanjaya, SH, MH.
Thank you, Dr. Pasek. Well, Excellencies, distinguished guest participants, ladies and gentlemen, as for our next agenda, now please warmly welcome the Dean of the Faculty of Law, Udayana University. In this occasion is represented by our Vice Dean, Professor Desa Putu Dewi Kasih, SHM Hum. Therefore, we would like to invite Prof. Dewi Kasih to please come to the stage. Thank you.
Thank you. Om Swastiastu. Assalamualaikum warahmatullahi wabarakatuh. Salam, Namo Buddhaya, salam sejahtera untuk kita semua, dan selamat pagi. On behalf of the Dean of Faculty of Law, Udayana University, allow me to deliver a speech on this occasion. Your Excellencies, our guest speaker, Mr. Fatos Selita Liakovas, our invited speakers, Bapak Igusti Ngurah Parikesit Pediateja, and Bapak Jai Maulana from the Faculty of Law, Udayana University, coordinator of the Master of Law program as the organizer, coordinator of unit, head of Department Law Laboratories, and participants and committees for this academic event. Good morning. First, let me express my gratitude to God because we can gather at this event. We are delighted and honored to thank all speakers, moderators, participants, and committee for attending this event. In particular, I would like to greet our guest speaker, Mr. Fatos Selita and Professor Yulia Kovas, and welcome you again to our campus. As far as I remember, the last time you were here at the same venue was when you became a speaker at our conference in 2019, especially to Mr. Fatos Selita. Thank you for replying to my emails 2 months ago, agreeing to our request to become a voluntary lecturer at our law school. I do believe your academic and practical experience as an international level barrister will be very valuable for our students. Besides this, I also admit your contribution to the Udayana Journal Law and Culture since 2017. Thank you. In addition, I do appreciate to the initiative of the Master of Law programs of Faculty of Law Udayana University to organize this educational event. Ladies and gentlemen, legal education for decades has been criticized for looking at law narrowly only in the meaning of norm. In reality, the development of law is very interesting and even heavily influenced by other disciplines. For example, economic and business development have given birth to law and economic, business law, and economic analysis of law. Besides this, advances in science and technology have led to adaptation to various formal written legal instrument. We observe that several kinds of research in the field of law reflect the non-allergic attitude to other disciplines. In fact, the outcome of those research significantly impact society. Therefore, we appreciate several law schools that explicitly show their position in supporting interdisciplinary legal studies. Thus, the topic of today's seminar has high relevance to end international disciplinary approaches in legal studies. To end this speech, I hope this seminar offers audience a new and inspiring insight to all of participants. Finally, I declare that the International Seminar on Disciplinary Approaches in the Legal Studies is officially open. Thank you. Om Santi Santi Om. Terima kasih.
Thank you, Prof. Well, Excellencies, distinguished guest participants, ladies and gentlemen, that was the opening ceremony for today's agenda. We would like to invite our Vice Dean and our coordinator program, and then also committee chairman, and then all speakers and moderator to please come to the stage for the photo session. Thank you. Okay, next for the second session, we would like to invite all participants to also join us for the photo session. Jadi Bapak Ibu dimohon untuk berdiri dari tempatnya masing-masing karena kita akan mengambil foto bersama terlebih dahulu. Untuk panitia mohon diambil gambarnya dari depan panggung. Terima kasih. Kepada Prof. Windia kami mohon perkenannya juga untuk dapat bergabung bersama kami di depan. Kami mengundang Prof. Windia. Dipersilakan, Prof. Okay, thank you. You may all be seated. Thank you. Baik Bapak Ibu, hadirin sekalian yang telah bergabung bersama kami secara online, kita akan segera memulai acara inti pada pagi hari ini. Mohon perkenannya untuk mengaktifkan kamera video Bapak Ibu dan juga untuk menonaktifkan fitur mikrofon di layar laptop Bapak Ibu demi kenyamanan acara pada pagi hari ini. Terima kasih. Well, Excellencies, distinguished guest participants, ladies and gentlemen, finally we arrived at our first agenda in today's international seminar. We would like to inform that the presentation of our speakers today, as well as question and answer sessions, is going to be facilitated by Bapak Imade Budi Arsika SILLM as the moderator. Bapak Imade Budi Arsika SILLM is a lecturer at the International Law Department at the Faculty of Law Udayana University. He obtained his bachelor's degree from the Faculty of Law Universitas Erlangga, while for his master's degree from the Faculty of Law Maastricht University, the Netherlands. And he is now the managing editor of the Udayana Journal of Law and Culture. And currently he is also a PhD student at the doctoral program at the Faculty of Law Udayana University in Bali. So without further ado, Bapak Budi Arsika, the time and place are yours. Thank you.
Tes. Thank you very much to the MC. Good morning, everyone. How are you today? Yeah. So this is a very nice event. Thank you very much for the coordinator of the Master of Law programs and staff for organizing this academic event and assign me as the moderator for this event. Vice Dean for Academic, Planning and Cooperation Affairs, and also we have the Editor-in-Chief of the Journal of Law and Culture here, Prof. India. Today, we will hold an international seminar, which will present 4 speakers. The first one is Mr. Fatos Selita, a barrister of England and Wales and an attorney of the state of New York. And then the second one, we have Professor Yulia Kovas, PhD, the Professor of Genetics and Psychology at Goldsmith University of London, as well as a visiting professor at New York University in London. And the third one is our lovely lecturer here, very famous, Bapak I Gusti Ngurah Parikesit Widya Teja, the lecturer at the International Law Department of this Faculty of Law. And the last one, actually a businessman and also approaching the legal practice, who is now taking a Master of Law program here, Bapak Jai Maulana. So please give big applause to the 4 speakers, and we would like to invite you to come here with me, please. So, Bapak, Ibu, today this event, the participant of this event is not only the student who attend the seminar at this venue, but we have also those who join by online means, by Cisco Webex. May I know how many participants? Berapa jumlah pesertanya? So we have participants also. Allow me to greet you. Yeah, we have 95. Yeah, 95 online participants. So please give big applause. And among the online participants, we have master student from other universities in Bali and also outside of Bali, and also a student from psychology department, yeah, that we invite through the online means as well. And we have here also our international students, Daniela from France, and also Laura from Germany, also here. Thank you very much for attending the session. Bapak dan Ibu, interdisciplinary, yeah, one word but has a very meaningful, yeah. We know the interdisciplinary, multidisciplinary, and also transdisciplinary. What is that? Yeah, hopefully the speakers will clarify and explain about this issue. But we choose, I mean, the committee of this seminar choose the term interdisciplinary. Yeah, it is generally understood that term interdisciplinary involving two or more different subjects of area or knowledge. Allow me to cite a research by, I guess, by the current dean of Airlangga University School of Law, Bapak Prihandono and Yuniarti. So it's quite new, I mean it's quite a recent research published in 2020 in a journal article. The research suggests that the number of interdisciplinary studies in Indonesia law school is relatively low compared to most other law school in Asian region. This is something like sad but true. And it implies that legal education in Indonesia follows a conservative teaching method, being very specific and independent from other studies. So I guess among the, let's say, law scholars, for decades, yeah, we can identify those who look the law and who, let's say, fuse the law only as a norms in a narrow sense. But thanks God for those who have tried to communicate, quote unquote, with other disciplines. For example, we have when the law scholars work with the anthropologists, then we have the anthropology of law. And here, Pak Bagiastra, the coordinator, said the course psychology of law is taught here at the master program. So it combines between, on the one hand, psychology, and on the other hand is the legal disciplines. And this trend, yeah, is, I mean, this is the current trends to combine, yeah, between the law and other disciplines. So this is the idea behind the why this seminar is organized. Yeah. And ladies and gentlemen, as previously mentioned by the MC, we have 4 speakers, yeah, to deliver their presentation, yeah, and it is very nice because the first speaker is the legal practitioners, the second speaker is the professor from psychology, yeah, and we have also a senior lecturers in law here, and also a businessman that become also the law student at the master level here. And allow me to facilitate this session. So for the first speaker, I would like to invite Mr. Fatos Selita, and allow me to read his CV. Yeah. Selita, tolong di. So, Mr. Fatos Selita is a barrister of England and Wales and an attorney of the state of New York. He's a lecturer and director of AIR courses at Goldsmith University of London since 9 years ago. With training in law, behavior, genetics, and psychology, Fatos' work focuses on bridging science and law. So this is really the interdisciplinary work that he has been doing. Fatos has taught internationally, including at Oregon State University, Tom State University in Russia, yeah, and then New York University, University of New Haven, Higher School of Economics, and just mentioned by the Vice Dean, Fatos accepted our request to become our the lecturer here. So please give big applause to Fatos. He has co-developed the MSc Human Development, Genetics, Neuroscience, and Psychology, and has taught several modules on this program. He is also a founding member of the Accessible Genetic Consortium, the founder of the UK, United Kingdom Law and Society Association, and the executive publisher at Legal Issues Journal. Fatos was previously associated with United Nations Commission on International Trade Law, or UN, CITRAL, and Goldberg Con Chicago. And since 2007, yeah, as mentioned also by the Vice Dean, he helped us to develop our Udayana Journal of Law and Culture with the coordination with Professor Wayan Windia. So, Mr. Fatos, I give the opportunity to you. You may deliver your presentation. You may stand up or just...
Okay, well, thank you very much, Budi, and it's really good to be here again. Maybe first because of such a grandiose welcome that we get. So this is really grandiose welcome, so thank you. But of course, as you perhaps have guessed, I have a connection with Bali, that's why I keep coming back. So it's also good to be here for that reason. And of course, with education, considering I teach in so many places. So now, I wish I could deliver this in your main language, because that way you'll understand a lot more than what you will when I speak in English. But I hope you get as much as you can, and even if you don't get something, please feel free to ask either today or by email. So it's no problem. So now what I wanted to address today is a question that perhaps anyone who studied law or even members of societies, when they choose, when they need legal representation or they go to court and are being judged for an action, is how do I become a good lawyer? So I want to become a good lawyer, or I want to become a good judge. What do I need to do? Right, so what must we do? Must we study law? What should we do? Do very well in law. And what I mean with good lawyer, how do I switch the slides? Oh, next. So now what do we mean with good lawyer? Right, so what do you mean with good lawyer? So good lawyer, perhaps, and by the way, when I'm delivering this talk today, it's based on the US and the UK legal system. So I don't know the Indonesian legal system, so I hope to learn more. But the view of a good lawyer in the UK and the US is generally somebody like this, right, who drives a fancy car, nice suits, right, or the next one, I don't know. Maybe this one is a good lawyer. So I want to become a good lawyer. Now, how do we define a good lawyer? Have you ever thought what defines a good lawyer? It's worth, for example, to just consider what makes a good lawyer. How do we decide who is a good lawyer? And if we want to address this question, we really must answer the question, what is the duty of a lawyer? So what does a lawyer, what do they need to do? What are they required? What's their task? Right, so the person who grows rice. Their duty is to produce rice, whatever, to grow healthy rice. What is the duty of a lawyer? Right, and we know that lawyers will need to defend, so basically to protect the rights of people or companies, but from actions based, in cases, in disputes that have led due to actions of people. So actions lead to something that ends up as a dispute. So now lawyers will need to protect the rights of the clients based on these actions they've done. So they need to somehow explain that these actions amount to this or to that. So it is really the actions of people that are crucial here. Now, when we consider actions, right, so we therefore need to know about actions, so behavior. So where does behavior come from? So if, for example, we are judging an action of Jimmy being aggressive towards Johnny, right? So where does that behavior come from? So what is the origin of behavior, right? So what is it the product of? So if you were aggressive towards someone, where does it come from? So how does it happen, right? And how much control do you have over that action? How much control does anyone have over their actions? Actions to, for example, even simple actions like to like or dislike somebody, to vote for or against somebody, to buy red shoes versus black shoes, to buy Singa beer versus, I don't know, right? So, how much control do you have over these actions? And that will generally depend, so basically that's, in a nutshell, is also decision making, right? So it has to do with decisions. So then knowledge of behavior and traits becomes crucial, right? And we even think simple things like, for example, you perhaps have two people, one you find more likable than the other. Now, why is one, right? Why is Jane more likable than Bella or Bella than Jane? Right? So how does it work, right? And we, of course, need to also know about how reliable is memory, because, you know, how reliable is memory, how reliable is attention, how biases affect us, right? So we need to understand these things. Now, we know from science that we know where the origin of traits, so we know the origin of traits. What are the traits a product of? And we know that virtually all human traits, all, right, so you name it, are a product of gene-environment coaction. So genetic makeup coacts with environments, produces a trait. So any of the traits. So that includes even so height, eye color, personality, intelligence, traits have the same formula. So we, for example, also know, because we are considering decision making as well, we know from science, just examples I'm giving you, right? We know, because of course these are just so you get the idea, we know from science also that the decision making process in the brain happens before we are aware of it happening. And it's up to 10 seconds ahead. So when we learn about the decision process taking place, it's a bit too late. So the main researchers in the field, for example, have described consciousness as the tip of the iceberg, something that comes too late. So the decision is happening before you know it. Right, and I've put there the paper for you to read, so that you have some sources there, or if you want to read about to get more in depth about free will. So the origin of traits, gene-environment coaction, decision-making activities, just as examples, decision-making activity happens before we know it. Right? So now the question is, are there any harms with lawyers, us lawyers, not having knowledge about human behavior, or because we are focusing on human behavior because it is actions, so it is the human behavior that is leading to something that we then need to deal with, to either to basically decide in court or out of court on. So are there any harms associated with us lawyers not having that knowledge? And generally lawyers would say no, because there is the law and there is the person, and whatever they have committed something, I apply the law. And that will be the general view, perhaps. But then we need to assess the facts. So we check the facts. So I'll give you some examples just so you have an idea of what can happen from lack of knowledge about human behavior, human traits. So these people you see here in this slide, they are people who were sentenced, who were in prison for the years you see there, starting from the top and going around. So the first one was 35 years in prison, the other one 23, and the other one 34 years in prison for things they had not done. They were sent to prison based on eyewitnesses confirming that I am certain this person did it. I saw them do it. They, for example, raped me, full stop. I know this is the person. And the legal, of course, the legal approach is that, well, if somebody is certain that this happened, then it must have happened. But that's not the reality with human memory. That's not how human memory works. So if we were to accept the scientific findings on human memory, we don't send them to prison on those bases. But I can't, of course, explain you now the memory so you understand it. You just so that you get the idea. So then, and these people were then later on freed from prison after all these years based on DNA evidence. So DNA evidence showed that there was somebody else who committed the crime, not them. And it's not few, but it's actually 75% of those who were DNA exonerated. So they were freed from prison based on DNA evidence. That actually were sent to prison based on our misconceptions on memories, pretty much, because we believed there, so we relied on the evidence of eyewitnesses. So they were sure it happened, and we accepted it, but actually all of those, so you can see the proportion, all of those in a darker color were actually sent to prison from misidentifications, right? So somebody saying they did it. And so that's not a small proportion. And then you have the other example of gender biases. So for example, that was the lack of knowledge about human memory and biases. Now, gender biases, for example. You perhaps have heard of gender biases being talked a lot more recently than it was before. And a lot of people, agree with it, a lot of people disagree with it, but we need to just look at the science, the findings. So there was a study done with the American Orchestra. The American Orchestra had at the time only one female. And of course, the people who are hiring the members of the orchestra needed the best players. They need an orchestra to be the best. They don't really need to know whether one is a female or a male. It doesn't matter, or any other thing, as long as they play very well. And so they said, well, we really choose the best, but the men are better at playing, the men that apply to us. Good, they said, well, that's fine, let's do a test. Let's get those who apply to become members of the orchestra audition behind curtains. So when they auditioned behind curtains, then the hiring was 50-50, right? But so we don't know that. So the eye tricks you before, basically just as you see somebody, the brain adjusts to saying this person will be worse than this person, or this person will be better than this person. So to put it in very simple terms, it's not quite like that. But basically because of lack of this knowledge of how the brain can, how these brain bugs trick you, you end up discriminating people. Does it make sense? I hope everyone is following so far. So, and this, it's not, so we have other key examples that you perhaps would relate with. Like one of the key things in court is, you know, the truth, right? And now judges generally believe that they can detect the truth, and I can detect who is lying. And I have trained judges and high court judges, and they generally believe that, yes, I can tell who is lying. And we take the extreme case about detecting whether your child is lying. So surely if one can detect a lie anywhere, one can detect it to their own child lying, because that's who you see every day. And there was a large meta-analysis conducted, and they found that actually even detecting your own child's lies is just above chance level, right? So detecting somebody else's lie, 50-50 or a little bit more, but that's about it. But we are sure we can detect somebody lying, who is lying, and then we can send them to prison on those bases, or we decide to represent them better or worse, because we don't trust our client. We say, actually, this client is lying. But actually, they might not be lying at all. It's just your perception that they are lying, and you don't know whether they are lying. That's the point. There might be a slight chance that you know, like above 50%, but not, you can't rely on that. Right, so that's another example. And then if we go a bit further, because you think, well, actually it depends on what court you go to and the seniority of the judges. And when I wrote this paper, I put this paper there. When I wrote this paper, I was speaking to a judge, a friend, a senior judge, and he read the paper. He said, I read your paper. He said, but I'm not sure we are biased. We are not at all biased against litigants in person. And he's not lying to me. That's what he believes, that they are not biased towards litigants in person. All right? And then, okay, that's, of course, facts show otherwise, but let's just look at some more sophisticated facts. So there is a court in the UK that there can't be any safer court, to my knowledge, on the planet for getting things right, because there are 3 highly qualified judges dealing with these matters all the time. They all are listing the same case as the Court of Appeal. You can't go higher than that, really. I mean, the Supreme Court is for other questions. So, and then a study was conducted by the UK Law Commissioner, and they found that for 36% of the cases, the sentence, criminal sentence, for the most developed area of law, criminal law, 36% of the sentence was wrong in law. Not just too high or too low, just wrong in law. So the wrong sentence issue, right? So even for a simple matter like this, and this is an example when you over-evaluate your abilities of how you can get right or wrong something, right? So, and then, okay, this is in one country. Let's look at another country. Within a city in the US, there's a very large study conducted, and they found, for very similar facts, up to 63% variation in sentence. So 2 young people, 20 years old, stole a chicken, one in one side of the city, the other on the other side of the city. There, the sentence between judges would vary up to 63%, right? For the same thing, stole a chicken, 2-year-old chicken, perhaps. So, and of course, it's not that they really want to sentence one more than the other just because they feel like that. It is the brain tricking you, biases, subconscious biases that generally that lead to those things. It's not that judges have any personal hate against their defendants. They don't know their defendants, highly unlikely. Some rare, very rare cases, right? So that is another example. And then there was this huge study done with immigration decisions, very, very, very large study, and they found that, for example, in the same court building, some people from, let's say, from Colombia, in this case they had 5% chance of success in front of one judge and 85% chance of success in front of another judge. right? So 5 to 85 for a life-threatening matter, you know, asylum, it's a big deal. 5 means you're almost certain you'll lose and you'll be sent back. 85, you're almost certain you'll win and you will stay in the US. So these are, again, examples of biases subconsciously, because surely generally they'll be subconscious. And then you want to go just a bit further, because you might think, well, maybe they have some, some judges have feelings against some nationalities and so on. Well, let's just take another case then. Just pure parole decisions. Parole decisions, somebody might go to prison, might not. Would you allow them free until the case is decided? And so there's this very large study conducted, and they found that as further away from the break and food time you go, further away from the food time and break you go, the more negative the decisions get, right? And it's not actually by small difference, and the study is huge, right? So it's a very large study. We're talking 65%. They go from 0 to 65. 0% negative right after the break and food, and just before lunch they get, so they get 65% negative. So in the graph, you can see the graph. In the graph, it looks like this. It starts, right? It starts positive, positive, and then drops negative, and then positive high up again, and then it drops negative again. All right, so the chances of you getting a parole would be 65% in the morning right after food, and they would drop to 0 just before lunch, and they would go back to 65% right after food, and they would drop 0 just before the day ends. Right, so now perhaps some people have children and know that as further away from food the child is, as the more difficult they become, but you don't expect us adults to actually react to the to the distance from break of food this way. You expect us to have control over our own decisions. But studies shows that actually we don't know that we are being affected. We are being affected by the distance we have from break or food. Right, so we will see how more studies perhaps develop in this field. Now, okay, so we talked about human behavior. So now we want to become good lawyers or good judges, right? So if we study law and human behavior, so we study two subjects together, because will then we become good lawyers? Is that enough? Right? And we don't know, because we can't assess, so we have to go back to the duty. What was the duty? And the duty, right, so duty has to do with us protecting the rights of our client that have to do with some action happening. So they did an act, it led to something, and now they are in they are in court or whatever, and we are protecting these rights. So now, okay, so we understand their behavior, we understand, so we protect from traps of decision-making, we protect from traps of judgment, biases, and so on. Is that all? We have to represent the clients as part of a legal system, for example, as part of a whole country structures. Do these need to be considered? We as lawyers are part of a legal system. So now, if we are part of a legal system and we are acting as part of it, we need to understand the legal system, right? So we need to understand the legal system. Now, what is the purpose of the legal system? And most lawyers I ask, they say, is to do justice. The main purposes of the legal system, what are they if you were to have 3 of them? And people just stop with justice. But is it? All right? And we don't know. We have to actually go back and assess what happened from the beginning. Let's say, if you start from Magna Carta, why was Magna Carta developed? What was it? And I'm not going to get into details with that, but you just need to study properly why were they created, what purpose did they have, who did they protect. But we don't have time for that, so we know there was, for example, a genius writer called Charles Dickens. I don't know if anyone has heard of Charles Dickens, but if you haven't, you can do a quick search. And he said, the one great principle of the English law is to make business for itself. And remember, English legal system is one of the best legal systems in the world. is to make business for itself. There is no other principle distinctly, certainly, and consistently maintained through all its narrow turnings. To make business for itself. Now, of course, the legal system has to make business. If it doesn't make business, it won't survive. So it has to make. Common sense will lead to you to, actually, if you assess properly, well, yes, if it doesn't make profit, it won't survive. So, but as a lawyer, you need to know this because that changes how laws are made, how laws are interpreted. Because if something is to make business, then the interpretation changes, right? So now we won't get into detail with that, but it means that one lawyer to be able to represent rights well, to do a good job as a lawyer, will need to understand the legal system well. Otherwise, they can't do it. They will just, navigate and make money and buy their Porsche if they are very good at that, but they won't really be a good lawyer. So, and examples of other key factors are, for example, economics. Economics play a key role on what happens with almost anything in a country, right, and in the world. So, because economics, for example, affects how the passing of laws happens. So, what influences the passing of laws? So, how are laws drafted? How are they passed? How are they negotiated? And a lot is to do with economics. Economics is a major driver. And of course, the link between economics and politics. One needs to understand, well, how are politicians elected? Who funds them? Who can dismiss them? Who can't dismiss them? These are important considerations because things have to work around economics, right? And then the understanding of politics, because to do a good job, to navigate the system well, and to be able to represent well, you need to also know about politics. Now, so we have all this, and it seems quite a lot to learn. So, how do we become a good lawyer? What do we do now? Well, and this doesn't apply just to a good lawyer and a good judge, actually. It applies to any field, but the short answer to that is you need a lot of knowledge, right? The question is, knowledge, but what knowledge? Right? So that's the little trouble we have. We have a little hurdle with knowledge. And the hurdle we have with knowledge is that there is too much knowledge out there, but is it real knowledge? And when I say real, I refer to a saying by Democritus 450 before Common Era. So we're talking 2,500 years ago, so these things are not new. And he separated the knowledge between, he said there are two types of knowledge, bastard knowledge and real knowledge. Bastard knowledge is all opinions, and things that are not based on facts, and real knowledge is actually the one that can be tested, retested, so real knowledge. So one truth, because of the access to so much knowledge, a lot of it might be bastard knowledge, and very little real knowledge, and you have to sift to know what is real knowledge and what is not real knowledge, because it is real knowledge you need. And then you also need to think, well, as a lawyer, if I know the acts really well, is that real knowledge? And that's for you to address, because you need to think, what is actual real knowledge? So, because if today we have an act, for example, that we disallow all people with green hair, and we say, knowing that law, I know that law well, and that is real knowledge. Is it? If tomorrow we change that knowledge to actually, tomorrow we don't allow anybody with yellow hair, what happens, what knowledge was it that we knew, the act that disallowed people having green hair? Surely it can't be real knowledge. And so then we need to be a bit careful. Just knowledge of the acts doesn't make us good lawyers, or doesn't mean we have knowledge. We have knowledge, but it's not real knowledge. And so you need to be careful to actually gain real knowledge. And you saw air courses at the beginning there, and there was a reason for that, and you see them here again. So we created air courses 2014 as interdisciplinary courses. So most air courses combine more than one discipline. So for example, law and psychology, genetics and law, public speaking with psychology, advocacy with psychology, right? So they all have elements of, they are combination of elements. And the journal I manage is also a multidisciplinary journal. So it only publishes things that have now, that have more than one discipline, right? So it consider each question from more than one angle. Now, as I said, I don't know how I'm doing for time, but it was, I know this is not easy, it's complicated stuff, but feel free to, any questions, I'll be happy to address even by email. So I hope you got something from it. Thank you.
Thank you very much for Mr. Fatos Selita. I guess the last third presentation is very interesting. The example of other key factors, economic, link between economics, politics, and the understanding of politics. Thank you very much, Mr. Fatos. We will invite you again later during the question and answer. Yeah. So now, allow me to invite the second speaker next to me, Professor Yulia Kovas, PhD, is a professor of genetics and psychology at Goldsmith University of London and visiting professor at New York University in London, Global Education, Oregon, and other international universities. Yulia is a chair of Psychology Ethics Committee and Psychology Research Committee. She is also co-founder of TAGC, the Accessible Genetic Consortium that aims to raise genetic literacy, promote beneficial use of genetic information, and prevent risks brought by genetics advances. I also would like to inform her academic qualifications. So for the lowest degree, 5-year degree for BA and MA in Russian Philology, World Literature and Pedagogics, teaching qualifications at Herzl State Pedagogical University. Is it in St. Petersburg? Yeah, in Russia. And BSc, yeah, honors in psychology, Birkbeck College, University of London, and then Master of Science in Social Genetic and Development Psychiatry at King's College, London, and PhD, this is the doctoral degree for behavioral genetics at the same also, yeah, similar at the King's College, London. So please give big applause to the second speaker.
Thank you very much, Budi, and thank you to everyone, to the organizers, to all the students. I know it must be very difficult. I've been there. When I moved to England and attended my first psychology lessons, classes at university, I remember how difficult it was, how little I understood, and how overwhelming it can be. But you can only get there by trying. So remember, the brain adjusts. When you have to learn new things in a language that is not your own, that's when the brain understands that language truly. So I know it's hard, it's a lot of information, it's not your language, but just by being here, you're doing something amazing to your brain and hopefully for your own lives and lives of other people. So thank you very much. Okay, so let's go. Thank you. So I'm going to talk about education. But as Budi already mentioned, my background is in education, in psychology, also in genetics. I teach genetics to psychologists and psychology to other professionals, including lawyers. So, but my passion is about understanding differences in education. Why do we learn so differently? Why different people succeed to different extent in education? But also why there are group differences in learning. As I will explain in a minute, we are going to look together at a very famous study. Who has here heard of the PISA study? No one? Okay, that's fine. So PISA is a program for international student assessment study, which assesses students' achievement in many, many different countries in the world. And they use standardized assessments so that in different countries they use exactly the same tests to assess students' reading, mathematics, science, and other aspects of students' development at age 15. So together we're going to look at the results of this international study in a minute. And then I'll ask you some questions, so try to keep with me. So let's go. So this is, I realize that this is very small screen, so I don't expect you to read anything. So I'll explain. So here you see, this is the whole world. Obviously, the study is not conducted everywhere in the world, so you can see gray spots, most of Africa, and some other places on the map. These are countries that are not participating in this study yet. And you can see different colors. So the colors in green are showing where students in the world are showing the best today, or this is 2018, the best academic achievement in reading, mathematics, and science more broadly. So these are countries in green. The countries in kind of yellow, orange, these are countries kind of average performance in the middle. And then countries in red are a bit worse, so they're doing worse. Different countries are in different categories. So I have highlighted in like light purple, you can see, I'm sure, I know everybody always looks for their country, so I helped you to find Indonesia. You can see that Indonesia is in the red, together with many, many other countries. That means that the performance, the student achievement could be better. Right? So and so is the case in every country. All countries want to promote student learning. So question to you, why are these differences? So why are some countries doing much better and other countries doing worse in terms of student academic achievement? So what are the factors? So you can see that it's definitely not some kind of split, west versus east. That's not it. Because you can see, for example, China is traditionally doing very, very well. So Chinese students are outperforming other students in reading, mathematics, and other sciences. It's not north versus south. You can see that there are all kinds of distinctions here. So, for example, you can see some green in the kind of Northern Europe. And this is Finland, for example, is doing traditionally very well in education. So what are the factors? Like, is anybody brave enough to shout out one? Like, what is it? Give me one. No? Difficult? Okay, well, maybe you're right not to say anything, not to single out one factor. Because actually there will be many, many reasons for why different countries performing differently. Go to the next, please. So, okay, so this is another slide. So again, I don't expect you to read anything, but basically here we see the higher the country is, the better the performance. And we have the more the country is that way to the wall, the greater is variability in student achievement within the country. So in some countries, students are doing very well on average, but there is big difference between students within the countries. Some students are doing really well, and other students are doing really badly. In other countries, students on average are doing very well, and actually everybody is doing quite well. So there is no big difference between students in that country, right? So Indonesia, you can see, is close to me and quite low. So again, that suggests that on average, students are not doing that well at school compared to many other students in the world, and they are doing similar to each other. So there are not huge differences, like some are doing amazingly well and some are not studying at all. So they are kind of similar to each other. But you can see that countries differ very much in where they are and how different students within the country is. So these are like a lot of information here, I know. By the way, PISA has an excellent website. You can go there and see a lot of information. Now, next. So what is going on? So we want to understand, like, why are these cross-national differences? What is it? Well, I can tell you straight away. There are hundreds of factors. It's not one thing. It's not one. So let's look at just some examples. Next slide. So one example. So here we're looking at the GDP. So this is gross domestic product by per capita, so per person. And you can see, so again, the higher the country is, the better the student performance. And the closer to the wall, the more money per person the country has, gross domestic product. So you can see that there is some relationship, but it's not a very good relationship. So it's not like the richest countries have the best performing education. It's not like that. If you study this graph really well, you will find that some relatively poor countries have, some of them have good education, and some of them have worse education. And similarly, very rich countries, so for example, do you see Qatar? It's by the wall. So Qatar is very rich in terms of money per person, but their educational achievement is kind of quite low in international comparisons. So it's not just about money. There is a relationship with money, but it's not very clear. Next slide, please. Okay, a lot of information again. So now we are looking at spending on education. So how much money a country has per student for their kind of educational life. How much is spent? Again, have a look. So we could expect that the more money per education per student, the better the performance. But it's not like that. Have a look. Most countries don't spend that much on education. So they're here next to me. They're all on top of each other. And yet, some countries are doing really well, and some countries not so well. And again, Qatar stands out. If somebody is from Qatar or from, wherever, don't worry, because it doesn't matter. We're just trying to understand what's going on. So in Qatar, again, a lot of money per student in education, but performance is average or even below. Next slide, please. Okay, what else can we ask? Like, okay, we looked at, economic factors. Okay, now something else, very interesting. So this is time per week, hours per week that students spend learning. So this is both at school and at home. So like how much effort is in educational system for individual students. Okay, so what do we see here? You see completely chaotic relationship. Like if you understand statistics, this is zero relationship. It means that in some countries, students spend a lot of time learning every week and doing very well. And in other countries, students spend the same number of hours and are doing really badly. And here the example I can single out is at the top there in blue is China. So you see China? So Chinese students spend a lot of hours, almost 60 hours, 15-year-old, 60 hours per week learning. And you can see they are at the top, they're doing very well. But have a look, another blue close to me at the top. Do you see Finland? They put the least hours of learning per week, the least in the world. And have a look, they're doing almost as well as China. So what is going on? So, okay, economics something, learning something, but it's very complex. Okay, let's look at one more factor. Actually, I'll skip this slide. Next slide, please, because we run out of time. Okay, this is a different, next one, please. Yeah. Good, so this one. I know you can't read it, but I will explain very quickly. So this is a little bit different, the slide. So what's going on here is proportion of students in the country who are learning at school in the language they do not speak at home. Okay? So do you see at the top of this graph, Lebanon? In Lebanon, more than 90% of children speak at home the language that they don't learn at school in. So almost the whole population. Now you can see Indonesia is very high on that graph. So more than 60% of students learn at school in the language that is not their first language. They speak something else at home. And have a look. So there is Indonesia, Malaysia, Philippines, very high. And then some other countries, you can see proportions drop right down. So it's now below 10%. In China, almost like 1% or something. In the mainland China, in the main cities, everybody learns at school in the language they speak at home. And actually, there is a lot of research today that shows that learning in a language that is not your own is a disadvantage. It can be an advantage. Like your brain develops, bilingualism is a powerful tool. But it can also be a disadvantage, especially if you're learning a lot of things at once. So, and in fact, studies show that students who are learning in another country, for example, in England, if you're a Chinese student learning in England, your grade is usually 1 grade below that it would be in China. Does that make sense? So, of course, it's a global world, and we want to learn in different languages, and in fact, we don't have a choice often. So this is something we have to live with, but we need to factor it in. We need to understand this. And so some countries perhaps are not doing as well as in international comparisons because of this situation as well. Does that make sense? Okay, so this is what I wanted to say about cross-cultural, cross-country comparisons. Next. So far, we've been talking about differences in education across nations. This is very global, right? And we are saying, well, why do we differ? Why do nations differ? And I've just given you some examples. There are many, many more factors. So there are some economic factors. There are some linguistic factors. This is a very ancient kind of, not ancient, but old diagram suggesting that, you know, this is you in the middle, and around you there are these different layers of culture. Your family, your immediate kind of family, and then there is the school, and then there is your parents' work, and then there is a major cultural kind of background in the country where you live. And so all of this bears down on you in the middle. So these are all the influences of culture. Good. But is that all? But it's not all, because we know that children differ in education, even within one family. So within one family, with the same parents, the same language, the same culture, the same educational system, the same so many things, and yet brothers and sisters often differ in how well they learn, how much they learn, how much they achieve in education. So what's that about? And here we need to look at some other broad layer of factors. And some of them are genetic factors. Remember at the beginning I said, you know, I teach genetics to psychologists. Well, genetics today, we live in the era of genetics. So we understand a lot about DNA. And what we now know is that family members differ from each other, partly because they have differences in their genetic code. Next slide, please. So I will say just a few words about my work, but also this whole field that is called behavioral genetics that Fatos already alluded to. So behavioral genetics is a study that tries to understand the interplay between environments and culture and genetic makeup that we have. And one way to do that is through studying twins. There are many, many twin studies in the world. There are many twins in the world. Approximately 4% of the population of the world is twins. And maybe you know that there are two types of twins. There are monozygotic twins. These are identical twins. Their DNA is completely identical because they come from one single cell that splits and they continue to develop as two people. So they are completely identical genetically. And another type of twin is dizygotic. So these are two independent cells fertilized by two sperms. So they are like any brother and sister or two sisters genetically. So they are similar but not identical. And twin studies study these two groups of twins so that we can understand these kind of genetic and family processes that contribute to similarities and differences between people. Next slide, please. So today, from many, many studies, we know, as Fatos already mentioned, that all human traits, health, well-being, motivation, personality, and education are influenced by genes as well as culture, environments, and other things. So we know this from many studies, but I have been fortunate to work for many years on this study. It's called Twins Early Development Study in the UK. And this study is very interesting because it follows the same people from birth, so when they were just born, and now they are young adults like yourself. So for more than 25 years, these people have been followed. So we know quite a lot of things about them. Next slide, please. So, so on this slide, you can see, for example, so at the top there are two girls, and then this is them, the same girls when they were 4. And these little children are already children of the twins. So now we have a new study going on that is children of twins. So you can see that there is a lot of information. Next slide, please. Okay, so this I'm not going to talk about here. I just want to tell you that there is a wealth of publications. So if you're interested in this topic, you just need to look genetics or twins and education, for example. And so these are just some papers from the teams with whom I worked, showing that academic achievement, motivation, personality, anxiety, all the kind of different characteristics that are important to education are influenced both by genes and environments. Next slide, please. And even more importantly, there is a lot of information suggesting that genes and environments interact. That, for example, a person with their unique DNA can develop differently depending on which environment they are developing in. So, for example, remember if Chinese students studies in England, they actually have worse grades? Well, remember, there are many reasons for that. So it's the same person with the same genes, but opportunity is different, and who knows what can happen. So genes and environments interact. And there is a paper at the bottom, actually, we co-authored with Fatos, which shows that if a country has a lot of inequality in the country, then actually genetic propensities, genetic kind of predispositions they do not have a chance to express. So when countries are unequal, they kind of suppress educational genetics. So I know it's a very complex concept. If you want to know more, you can read this paper. It's open access. Next slide, please. Okay, so just a few more words about genetics. maybe you know, maybe you don't, that before this century, it was kind of conceptualized. People thought that one day we will find a gene for every trait. So, for example, there will be one gene for cancer, one gene for mathematical talent, one gene for, I don't know, music or something. So people really thought that genes have this really like strong effect. If you have this gene, you are a mathematical genius. If you have this gene, you are not. Today we know for sure that this is completely wrong, completely wrong. In fact, genetic effects are usually very small. So if we find one gene, it makes only a very small contribution to anything. So this is like, you see, this is a heap of hay. And, you know, before they thought that you can find a gene like it will be sticking out like a huge needle in the haystack. But today we know that actually we need to look, genetics will take a long time because you need to find many, many, many genes of very, very small effect. So genes work in a very complex way. The same way as environment. Remember when we said, why are some countries not doing so well in international comparison? Well, it's a very, very complex question. So many factors. Okay, next slide, please. So, but I'm leading to law now, so almost near the law. And I know I have like 2 minutes. So, nevertheless, genetics is becoming part of everyday life. Today, already, in many countries in the world, if you're complaining about something, medical problems, you can have a genetic test, and you will receive some information, some probabilistic information. It means that they won't tell you, oh, you have this gene, you will have this problem. What they will tell you is that you have this gene variant, or these gene variants, and therefore, there is a risk, 10% risk, 5% risk, 1% risk, 80% risk, that you may have something. Do you understand? This is a probability. So it's not certain. But people use this information already. They use it about medical things, but they are beginning to use it about other things. For example, in the future, you may have a genetic test and ask a question, will my child be very good at education? You understand? Now, the answer will not be yes or no. It will be this kind of probability that your child may be amazing at mathematics. Does it make sense? So this is called probabilistic prediction. So we predict based on a lot of information, cultural background, all kinds of things, languages, but also perhaps genetics. Next slide, please. And today already, you can, and we are now in the century of consumer genetics. You can send your DNA in the post, just some saliva, and you will receive information from a commercial genotyping company. So for example, at the bottom, you may not see it, but I've pasted, this is something you can do today. For 300 pounds, you can send your DNA and receive some information. The company tells you, they will give you information on ancestry, health, some kind of medical things, sports, skin care, and talent. Do you understand? So that's what they promise you. But it's not true. You can pay 300 pounds. You can receive the results, but you won't know anything. Because information is not good. Because it only gives you a very small glimpse into what can be. But people will use this information. They will worry about it. Parents can make decisions about it. our societies can restructure based on this information. And so I come to my final slide, to law. So we need, this is how law comes in. Today's world is full of new knowledge. Like Fatah said, like, what's the good knowledge? Like, where to look? Well, you need to know a lot so that you can evaluate what I can trust, what I should look at. But also societies need to build structures that will allow positive use of this knowledge. So, for example, genetics currently is not regulated, not very well. Well, Fatus is the expert, you can ask him questions, but not very well. So, for example, should parents be able to send DNA of their children in the post, receive information, and make decisions? Well, societies need to decide whether and how we are going to use genetic information. So, I want to say that this kind of ability to use genetics in education has been called, there is a paper about it, it's called mixed blessing. So it can be very good, but it can also be very bad. So societies need to make a lot of decisions, and lawyers are the key workforce who will be helping societies to adjust to these decisions. That's why I think, and Fatas thinks, and many of our colleagues think, that lawyers need to learn about psychology and genetics. Thank you very much.
Thank you, Julia, for the very interesting data, including Indonesia. Yeah. So you arguing that lawyer needs to learn genetics, psychology. Yeah.
A little bit usable information, not become experts, but know something.
Yeah. At least know the basic understanding. Thank you. Julia, I have also a twin girl toddler. I guess you forgot to put the picture of them.
I know, I need these pictures.
Yeah, thank you. Ladies and gentlemen, please allow me to say some greetings to our friend. We have now 123 participants who joined the seminar by online means. So please give a big applause. Yeah. And I checked the name. We have the participant is not only from Indonesia. We have the judge from Timor Leste, ya, Bapak Duarte Tilman Suarez. Thank you very much, Pak. Always support us. We have also Professor Retno Murni, Professor Sudarma Sumadi, and the former Justice of the Indonesian Constitutional Court, Bapak Dr. Dewa Palguna, and senior lecturer from Undiksa. So Undiksa is a university in Singaraja in the north of Bali, Bapak Dewa Gede Sudipe Mangku. So, and also Dr. Miranila Sumadewi from the University of East Indonesia. So thank you very much for joining this event. Ladies and gentlemen, two speakers have presented their presentation, and now I'd like to invite the third speaker. Yeah, he is the Bapak. Actually, his nickname is Pak Sigit, ya. So his full name is I Gusti Ngurah Parikesit Widyateja. He's a lecturer at the International Law Department at the Faculty of Law Udayana University. He completed his Bachelor of Law from the Faculty of Law Brawijaya University, earned Master of Laws from the same university. In 2014, he completed his LLM from Global Business Law at the School of Law, the University of Washington, Seattle, the United States of America. 3 years ago, he earned a PhD degree from the School of Law of the University of Melbourne. This is one of his achievement. So 2 years ago, he was awarded as the second best lecturer of University of Udayana in social science category. So please give big applause. His research interest covers let's say, the planning law, tourism law, and international trade law. And presently, he's also the coordinator of Udayana Law Journals. So, without further ado, I'd like to invite Bapak Parikesit Widya Teja, PhD, to present, to deliver your presentation. Please.
Thanks for the opportunity, Mr. Budi as moderator. Assalamualaikum warahmatullahi wabarakatuh. Om Swastiastu. Salam sejahtera, salam nama budaya, salam kebajikan, salam sehat. It is definitely my pleasure to speak in front of you in such interesting and inspiring event today held by Master of Law Program, Faculty of Law, Udayana University, not just because the event, but also because the title of the seminar also important, because especially because I saw the audience come not only from undergraduate, but also from graduate students in law faculty. And in this occasion, I'd like to deliver materials about law, economic, and environment toward a good regulation amid the race between economic and environmental concern. So I just want to show and share if when we study, when we are doing research in law, then we have to be aware that the legal problems that we face sometimes come from something beyond the law. So in this regard, then I will explain the connection between law, economic, and environment, and what will happen if the law itself fail to accommodate, to combine, to balance the competing interests between economic and environment. And also, at the end, I will give some recent cases, just try to be a trigger to the audience to also think about, and even that you can have critical analysis about the cases. Okay, and another important thing that I'd like to address is because my presentation mostly about, I just want to offer any possible theories, other than we have like mainstream theory, because from my experience as a lecturer, I've been lecturing for almost 10 years now, and every time I check, I review some final project cases or dissertation, there are like a habit in when you cite some theories in doctrinal and then empirical, I just realize some trend. For example, when I check like a doctrinal or normative research, the theory from Gustav Radbruch, the theory from Hans Kelsen, Hans Nawiansky, or even in Indonesia like Philippus Hajon or Maria Indrati are always appear. And also, if I check the empirical or social legal study, the theories from Lawrence Friedman are always appear. It's something like advertisement, apapun makanannya, minumannya teh sosro. Whatever the case, the theory must be Lawrence Friedman. So, in my presentation, then I'd like to offer, this is offer, maybe some available theories that explaining the interplay between law, economic, and environment, and maybe apply to your cases. Then you can check further, because every time I quote some possible theories, I will always refer to the primary resources. So I also suggest for students especially, if you cite some work from legal scholar, some work from Hans Kelsen, for example, you have to get the book from Hans Kelsen itself, not from secondary or tertiary resources. That's because we know in the language we have like a barriers, we have the different capacity, the different ability to digest, to understand the meaning of any kind of theory. So from the structure, after explaining the interplay between law, economic, and environment, then I will explain the theory about what usually make a regulation fields, and it will compare the difference between, or the competing interest between economic and environment. And then I will make some like a claim that usually when economic and environment are in the same interest, then usually the economic one outweigh the environmental concern. And again, I will offer some theory that explain about how, a good law, a good regulation to balance the risk between economic and environment. And recent case example as illustration for you to consider. Okay, for the next slide, again, I just have 20 minutes, and I hope you will have my slide as well, because all my slide will refer to the first resources. So after this, you can go to the e-books, go to any possible platform to check and then to explore, and maybe some available theory. Again, I said possible theory, I just offer, and maybe it will apply, it will suitable to analyze as a legal analysis for your research. And also because, again, this is about the connection, the interplay between law, economic, and environment. For example, I will refer to the first theory about the Talcott person when he said that the structure of social system is determined by 4 social institutions, namely adaptation, refers to economic, goal attainment, refers to politics, integration, refers to the law, and latency, or culture. So I have, maybe it's not really, maybe I'm sorry if my illustration little bit is not convenient maybe from some of you, but we have like different mindset, from the past generation, the second generation, the current generation, and then the next generation about sex before marriage. And that issue can be applied with the case of Talcott person. For example, my maybe grandma or grandpa generation, the rule is clear. You never have sex before marriage. That's the rule for the first generation. And the second generation, this is just illustration. This is not talking about good and bad, And the second generation will say that, okay, you are gentlemen. If you have sex with someone, then you have to marry with her, because that's the rule for the second generation. And the third generation, the instruction could be different. Never married with her before she got pregnant. That's the third rule from the third generation. That's illustration. And I don't know, in the future, it could be you can still have a kid, although you have not married. And in coincidence, we have also constitutional court decision that arrange that if you have kids, outside the formal marriage, then the kid has a legal protection. Is that right? Yes. So why the perspective is changed time over time? Yes, because this theory, Talcott Parson, can explain the economic, maybe this practice have been initiated by community from richer and influential generation. They interact with someone with liberal in political, and then the law, remember, the law is not always written law, but also unwritten law, and then the law is failed to accommodate that issue, then it's become a culture. That's why the Talcott person said, this is latency. I just remember in Orde Baru, in Suharto era, we always get doctrinized by saying we have to be careful with bahaya laten PKI, for example. And the word latency comes from Talcott person theory. So this is, again, this is just introduction. I know 20 minutes is not enough to explain all the story, especially to show the interplay between law and non-legal or non-legal factors. Or maybe I can refer, for example, in the theory of Karl Marx, for example, that he said that, expressly state that the law is the product of economic forces. Even Karl Marx, do you know Karl Marx, right? How socialist he is, then he can also state that, the law is product of economic force. That's why it will relate why the economic development, economic growth is become top priority. Sometimes economic development can disregard law because of the power of economic. This is just the example how the interplay between law, economic, and environment. And then in the next slide, I will just quote one, I think this is, not many people in Indonesia refers to this theory about the regulation fields, especially Lon Fuller in 1969 in his book, The Morality of Law, then explain any possible situation that make law is failed. And then you can check, if one of the qualification from each proposition happen to your case, then the law could be failed, And now, from the lecturer perspective, just for lecturer now, we have like a new rules, Permenpan RB number 1 2023, that require more administrative requirement for lecturer to submit administrative staff that can adversely impact the life of lecturer. Then if this rule is not comprehensive, is not, or it's create any compliance to be impossible, then the regulation could be stated as failed. This is the proposition, and maybe you can consider to put to your final project. And also, this is also interesting. Again, I always refer to the primary sources just to help you to explore, to start identifying maybe the story applicable to your cases. For example, I know this is in social media era, we always capture a good moment, and then we can upload it into social media. But what will happen if the law or the regulation are also captured by politics, for example, by economic, for example, or even by culture. And there is also theory from Gunther Tübner or Anthony August explaining this theory. If I am the leader, and then I remember my wife has catering company, then I will ask people within my community, in every seminar, in every international event, the company must come from my wife's company. So, as a leader, I've got distraction in the language of Gunther Tübner. He said the law has been economized. Next year, we have election. Be careful. Some political get politicized by his policy because they think about 2024. Yeah. They will always remind themselves that every time that must be connected in the election of 2024, because there is theory to explain that phenomenon. And that's actually normal. But again, the law becoming a key to balance these competing interests. In the next slide, this is the trend when the economic and environmental in the competing interest, then usually the economic is more or becoming the top priority. Yeah, and you can check some study, for example, in 2008 from Go and Ma, how the higher level of pollution, especially in environment, happen while developing country choose industrial policy, but still using low level of technology. Yes. And also, in the next slide, I explain about the trend about planning gain, when some administrative or some leader then can pursuing personal or group interests by receiving material benefit from a permit process. It's known as planning gain. Yeah, I know, for example, in Nusa Dua, for example, I just imagine myself as a leader. In Nusa Dua, I know in some area are in conservation area. You cannot build anything in the conservation area. But I remember next year, I need more money to run for the election. Then there is a potential investor want to build a prestigious hotel in the Nusa Dua. So what should I do? I don't have enough time to think about. Then, I will do planning gain. I will allow the investor to build in the conservation area. Then I will make a law to change that conservation area into commercialization area. That's the real example of planning gain and any other cases. Okay, the next slide, I explain about a good regulation, and I think this is just a proposal, introduction, maybe some available theory can help you to analyze, also to understand this phenomenon, how to make a good regulation and what the qualification of good regulation. It is a bit, you may think this is a bit normative at the first, but when you go into the detail, go to the deeper analysis, then you will understand the important, we have like a good governance principle in the public and state governance, and then we have also good corporate governance in private matters. Then I think those two governance has a connection with the good regulation theory. And I just cite some cases, the examples that show the competing interests between economic and environment. For example, into the case of job creation law, maybe you are still aware the process, the issuance of this law, how this law has been changed 3 times, 2020, and then it has like government regulation in lieu in 2022, and then I don't know yet the number for the new regulation regarding job creation law. And also the government also want to move the capital into the Nusantara, Borneo, and there should be any comprehensive analysis how the environmental issue has been anticipated. Yeah. It is very dangerous if the new area of capital, for example, is not safe in terms of natural disaster, or maybe too close to neighbor country. So the country, for example, can build like military fort near the Nusantara. If these things are not properly considered, that will be pretty risk. And also some major infrastructure project in Indonesia. We have so many new infrastructure projects, and we have to be aware not all projects have put environmental consideration. Why? Because I have also in the next slide the past experience from the previous administration. Yeah. For example, we used to have like MP3EI, why the government unilaterally decide, okay, we have to build major project like port, like airports, and also toll route, and highway project, and they all disregard existing special plan. If regional or local special plan are not followed, then the plan should be modified or should be revised. And this practice occurred in the previous administration. So again, this is very challenging as a law, as also for you students to understand the interplay between law, economic, and environment, because from the available theories, there should be always non-legal factors behind the law-making process, the law implementation process, and also the law enforcement process. That's why in law we have like das Solon, das Sein, law in the book, law in action, and etc. Okay, I think that's all my presentation. Hopefully I give you some new insight and information about this topic, and thanks for the opportunity. Om Santi Santi.
Thank you very much, Bapak Gusti Ngurah Parikesit Widyateja, for presenting your presentation, and maybe for Fatos and Yulia and for Daniela and Laura, Pak Parikesit just mentioned that Indonesia is established a new capital in Nusantara, in the east Borneo, East Kalimantan. So yeah, there are many major infrastructure project there. Yeah, hopefully there is no problem with environment, Pak Sigit. Yeah, and it is also very interesting. Pak Parikesit mentioned, citing the Gunter Chubner, yeah, that mentioning the regulatory trilemma, the law can be politicized, the law can be economized, and as well as can be pedagogicized. So thank you very much, Pak Parikesit. Now I'd like to invite the fourth and the last speaker. So his name is Bapak J. Maulana SH, also known as VJ, Pak. Yeah. So he's a businessman at Side Decor, Bali and Jakarta since 2 decades ago. Yeah. He obtained his bachelor degree in law from Open University Indonesia, and he obtained a mediation certificate from FHP Law School Indonesia and passed bar examination year in the 2022. Currently, he's a student for master degree in law at Faculty of Law, yeah, since 2022, Pak. Yeah, please, Pak, time is yours.
Thank you. Om Swastiastu. You know, this is a very beautiful thing about being the last speaker, because all the topics, the complex topic, has been completed by the speaker. I'm just left with a small piece, you know, and it's easy and basic. So thank you for the speakers for the presentation. My dear, respected and honorable coordinator of Master-in-Law, Pak Bagiastra, the head of the organizing committee, Pak Pasek, honorable speakers, professors, barristers, moderator, and our future lecturer here. I think he will be lecturing us for the international trade law in the month of May, maybe, in our business concentration, hopefully. And my dear friends, ladies and gentlemen, the one who is watching us here, greetings from Indonesia to Timor-Leste, my brother from different father and different mother, Mr. Duarte, attorney, state attorney in Timor-Leste. Before presenting the slides here, I remember a story of Abraham Lincoln. He was the 16th president of the United States, you know. And it's customary there in America, after the oath-taking ceremony, the president will address the Senate. So during his first address, in the middle of his speech, you know, the senators interrupted him. And he asked him, Mr. President, you are just a family of shoemaker. What can you do for America? Lincoln is a smart guy. He is a lawyer. So he said, this is my word, huh? But a kind of real story. He said, yes, my father is a shoemaker and he makes fine shoes. and I learn from him also. Now, if your shoe is having problem, come to me, come to my house. I will do it for you. It isn't as good as my father's shoe, but I can make it all right. No, the rest of the story will be a suspense, because I should give you a plot twist here, you know. So may I present you with the slides now? I think it will be short because it's self-explanatory, and by reading it, you will understand. I'm giving you only the basic of what is interdisciplinary, not giving you explanations about the multidisciplinary or transdisciplinary, as our moderator was saying. So it's just interdisciplinary. Okay, with the topic here, the urgency of interdisciplinary towards legal studies in Indonesia. Second slide, yes. So we start with the basic of the meaning of interdisciplinary. I put forward here 3 definitions, but the second definition from Cambridge Dictionary suits me. You know, it's easy and not too difficult, easy to understand. That defines interdisciplinary as involving 2 or more different subjects or areas of knowledge. That is, I think, it's very easy to grasp, you know, the meaning of it. But actually inter means between, and disciplinary means it's derived from a Latin word disciplina, means teaching or knowledge. But all the same, it's defined in short sentences from Cambridge Dictionary. Okay, now we'll explain you, or we'll present you about the background of interdisciplinary and how is it important in Indonesia to know about it. Because law is a very complex discipline, but it's a very important one. Because Indonesia is a nation based on law or supremacy of law. Mind you, challenging here the pure theory of law by Hans Kelsen, but it's a different approach of interdisciplinary. And you know, we need a deep understanding in its application due to the complexity of the nature of law, involving many aspects of life, but not limited to politics, social, economy, culture, environments, technology, philosophy, psychology, history, which was explained by our honorable speakers here, the psychology, and legal professions has changed dramatically over a few decades, and today is not what it was before. Lawyers doing corporate transactions need different skills from lawyers working on the intellectual property. As well as lawyers working for health law needs different base of knowledge from a lawyer serving as a general counsel in a high-tech firm. So the good lawyer was explained by our barrister here, and hopefully I will be a lawyer next year, and a good one, after your advice. Interdisciplinary approach helps students, practitioners, scholars advance their critical thinking. cognitive abilities, that is brain-based skills and mental processes that are needed to carry out their tasks. Particularly for students, they can cover topics in depth because they are considering the many advanced perspectives from which legal topic can be explored. It develops structural knowledge, that is factual knowledge or information, and procedural knowledge, process-based info, which are needed to solve complex legal problems. And it will also help them for their betterment of understanding in a wider context and prepare them in facing variety of legal issues. Interdisciplinary approach will also help them in strengthening their competence in many ways through their developed critical thinking skills to solve unique and complex legal challenges such as human rights, environmental protection, and that is why they must apply it in their legal studies so that their approach will be holistic and comprehensive. So the formulation of issues is why we need interdisciplinary approach towards complexity of legal studies in Indonesia. And how are the interdisciplinary approach help students, practitioners, scholars in understanding law in a wider and complex context. So the discussion will be, it's too small, I suppose, but I can read it out. It's just a self-explanatory, so don't worry about explaining again, because after reading it, you will, I hope you will understand it. As you know, the nature of law is complex and it cannot be realized from one perspective, discipline. Legal studies involve many aspects of life, such as explained above, political, social, economy, culture, etc. In the Indonesian context, interdisciplinary approach in legal studies plays a very important thing due to the complex legal challenges that Indonesia is facing and the involvement of other disciplines. So now we base it on the theory that is actually education theory, but I put it in such a way towards education in legal studies. The theory is called constructivism theory, and that theory suggests that people create their own understanding and knowledge of the world through experiences and reflection on those experiences. And it goes on suggesting that when students encounter something new, they must integrate it with the previous ideas and experiences by connecting the new knowledge to something already known, which requires students to ask questions, explore, and assess what is known and learned. Students engaging in interdisciplinary study are therefore creating their own understanding and knowledge of the world through their study choice. Towards the context of legal study in Indonesia, this theory has a tight relationship with the urgency of interdisciplinary, and it is because to understand law comprehensively and in depth, we need also to understand other relevant disciplines. Combining the variety of disciplines, law students will be able to understand law as social phenomena, which is complex and dynamic. Which is why law students should be given chance to study other discipline, and not only from one point of view, discipline that is legal only. In conclusion to that theory, This will help and encourage students towards interdisciplinary approach for their legal study in Indonesia. Sorry. Applying interdisciplinary approach in legal studies, students, practitioners will be able to integrate variety of disciplines to gain holistic understanding. For example, legal issues in regards to environment, they'll have to consider economic, political, and social aspects so that it will make them understand the issues comprehensively. In other words, interdisciplinary approach will also help students, practitioners in understanding on how they can apply the law in variety of situations. Now, the plot twist is about the shoe making by Abraham Lincoln. We'll be trying to explain you from a simple thing to a complex things, not the other way around, from complex to simple. But I think it's easy for me or for you to understand from simple things becoming a complex thing. And if I may, that shoe, I may call it as a shoe theory. Now, if you see a shoe, what do you see? It's just a simple, simple wear for the foot. But it's a complex thing, actually. You need, for the sole, you need the leather. For the upper sole. For the down sole, you need a rubber. And or wood for the heels. Okay? So for the wood and the rubber, you need, okay, this is the downstream. The upper stream will be the legal. All the upper stream will be the legal. You need to go to the forest and choose which is the wood that suits the shoe, or which trees that we can extract a liquid for making the rubber. And forest, we need environmental law, which trees to be protected and all, not to be exploited and everything. And we need to go, which is the wood the best for the shoe. Okay, that is the legal thing. Now, for leather, which animal skin? For the shoes, maybe sheep skin, goat skin, cow leather, or now advanced to fish skin, which can we are not talking about the ladies' shoes because it's too much complex. We are talking about the gents' shoes, which animals are protected. Maybe snake's skin or alligator skin, but they are now protected, I think. So, needs the law. It needs the law. And then, now, for the laces, we need the thread. From where? It also concerns the law about the thread. The third thing, the fourth thing, I think, now we have to think. We have to think about the model. What models suits which occasion? For parties, we have some models. For the everyday wear, we have other models. So now we have to do some research and find a designer. That is art. Art, and then the next thing to do is we go to the IP office to register our models, and then also naming the shoe, like Lincoln shoe, we have to register it in the trademark office. It's legal also. The next step is how to market it. No, before that, the size of the shoe. How to do the sizing of the shoe so that it's comfortable for the fit. We have to do research again, we have to make samples again, and then invite some people for wearing it and giving us feedback. Is it comfortable on what to do, how to improve it? Okay, we need research. And then after that, it's the business side. Now we have to form a company. It involves legal. We have to form a factory. We need legal, how to do it. And we need a machinery. Importing the machinery, we need the license and we need legal again. And we need people to do it. Industrial law. Marketing it, expansion of it. We need credits from the bank, banking law. And if we expand, if we want to expand it, and then we want to make it a public listed company, stock exchange law. So this shoe, this a small shoe, is giving us complex issues. Towards the end of the upper stream is the legal. Now, that's why I told you about the from simple to complex, because it will be easy for you if you go around from complex to simple. Legal is complex, but it needs, from that story, it needs environmental know-how. It needs art for designing it. It needs psychology or sociology to know the behavior of the society, of how they are wearing the shoes, in which occasions, with heels, no heels, what the models, we need that. And then we need economy law, for the banking law and everything. And we need industrial law, needs how to deal with the people who are working as labor in the factory. That is what we call interdisciplinary. So that law or legal cannot stand without other subjects or other disciplines. We need to know them. We need to know them. It's not in depth, but we need to know the basic of everything. It's not just to say we are jack of all trades. No, we need to know the basic things of all the subjects in relate with the legal studies in Indonesia. That's what, the creative or the creative thinking and imaginary innovation, imaginary mind will come out so that we may face the legal problems here in Indonesia. So to conclude it, based on the discussions above, it can be concluded that the legal studies with its complexities needs interdisciplinary approach. Law involves variety aspects of life related to other disciplines, and as such, it needs broad understanding and holistic so that it can effectively applied in real life. Using interdisciplinary towards legal study, students and or practitioners will be able to understand legal issues comprehensively and how they can apply law in a broader way. This way, it will help and prepare them to face the variety of legal issues. Interdisciplinary approach towards legal study in Indonesia should be applied more extensive so that students and practitioners will be able to face legal problems or issues in the future. Proposition is one of the biggest barriers to achieving more true interdisciplinary approach towards legal study in Indonesia is the necessity for collaboration of educators of variety of disciplines so that they may form a compact curriculum of other disciplines in regards to legal studies. And two, interdisciplinary approach in legal studies in Indonesia I think it should start as early as from undergraduate law program with just the basic. So this is the end. I told you, right, it's simple and short. I know that now I can hear the music from your stomach with rock and roll genre. It says, hungry, hungry. So I stop and thank you very much for the chance of giving this presentation. With the saying, you know, Loka Samasta Sukhino Bhavantu, may happiness be bestowed to all of us. Om Shanti, Shanti, Shanti Om.
Thank you very much, Pak Jai Maulana. So you are supporting the interdisciplinary approach toward legal study. Yeah. So you think that students and or practitioner will be able to understand legal issue comprehensively by this method. Thank you very much, Pak. Ladies and gentlemen, now allow me to facilitate this session for the QA, the question and answer session. But please understand, we have only a very limited time, and I have seen there are questions by the online participants, but I only choose one questions. But I would like to invite two participants at this venue, I mean the offline participants. If you have a question, please raise your hand. Please raise your hand. Oh, we have one, yeah, on the corner. One more students, or lecturer or student? No? Okay, now I invite one. Okay, please mention your name and to whom your questions to be addressed, please.
Hello. Before that, let me introduce myself. Niputu Ayu Libranti. Call me Libra.
Excuse me, Libra.
Yes.
Libra, thank you.
With the final number 1129. If we interdisciplinary approaches to addressing educational challenge, psychology, genetic, and law, here I ask, all three of which will affect people's life for the future, and is there a reason for that? Thank you.
Excuse me, is there a reason for?
Yes.
Could you repeat, please?
Question. If we interdisciplinary approaches to addressing educational challenge, psychology, genetic, and law, I ask, all three of which will affect people's life for the future, and is there a reason for that?
Okay,
Thank you.
Do you address the questions to one of the speakers? Or to
Yes.
Professor Yulia?
Yes.
Yeah. Do you get the question?
Yes, absolutely. Thank you very much for your question.
Okay, please. Professor Yulia.
Well, education is very important. So education is the most important social engineering project that humans have developed. So, and education is not perfect. Education is, has a lot of challenges, some of which I outlined today, that there are big differences among people in how successful they are in their educational background. For example, within one country, any country, there is a variation from about, if we just take this one study, PISA study, so the scores within one country differ from 200 to 650. So this is the same children of the same age in the same educational system receive scores in the national exams between 200 and 600. Now, this difference indicates approximately 10 years of study. So at the same age, two children in the same country score as if one had 10 years of studies and one had none. So this is the incredible gap between individual children within each country. And this wide variability is observed in every country in the world. So the question is why these differences are there and how we can help every child to achieve better educational standards. So that's question number one. Now your question is like, why is it important, right? Well, there is a lot of research that shows that education is our number one kind of factor that allows us to live a better life. So there is a lot of research that shows that even a small improvement in reading scores can lead to an extremely important difference for your life in general. Not just education, but your job, your health, your well-being, everything is related to educational success. So education is at the center of our lives. It's very important. And as all the speakers today have mentioned, I love the shoe example, you cannot solve it within the educational discipline because education has been around for centuries. And the incredible challenges that we have in education are still with us. So you cannot solve problems of education within a discipline of education. You need geneticists, psychologists, lawyers, philosophers, ethicists, economists, sociologists, all the disciplines that are about humans to work together to make people's lives better. I hope it answers your question, at least a little bit. Thank you.
So thank you very much, Professor Yulia and Saudari Libra for the questions. One more question from the audience at the aula, at this hall. Yeah, we have one lady to whom, okay, please mention your name. Yeah, and after the questions from the participant at the hall, I will invite the online participant. Please, lady, may I know your name?
Good morning, everyone,
Please.
and I guess good almost noon to everyone. Let me introduce myself first. My name is Elise Niting with the student ID number ending in 124. I would like to ask a question to every speaker, but especially to the first speaker.
Okay, first speaker.
You mentioned that in order to, you have mentioned that humans have subconscious or unconscious biases. I guess we can conclude that this somehow affects the way that judges kind of delivers justice to the victims in a courtroom, perhaps. You have also mentioned that, in a way, in order to fight this, we need to learn, we need to have more knowledge, more than law, basically, as law students, as future lawyers and judges. My question is, since it is subconscious or unconscious biases, do you think it is enough that we understand that we have this unconscious and subconscious biases? And if we already understand that we have these biases, do you think it is enough for us to consciously kind of fight against that to gain justice? And if you think, I guess the wording that I have is a little bit strange, so please forgive me for that, but I guess the basis of my question is, do you think as us, future lawyers and future judges, do you think that we have to, in a way, give up on the fight of justice because of this unconscious and subconscious biases? Or do you think that there's a way for us to fight this in order to achieve, in a way, true justice? Thank you so much.
Yeah, thank you very much. I guess I get the message. Should we, I mean the future lawyer, give up or fight against to get the justice? Thank you very much, lady. Yeah, I would like to invite Mr. Fato Selita.
Okay, good. So I hope I understood the question correctly. So I'll give an example, perhaps this is the easiest way to explain this. So if, for instance, the police force and the judges arrest and sentence more green people than yellow people, right? So the police force arrests a lot more green people than yellow, and judges sentence much harshly the green than the yellow, then a way to get around that is not to learn that there is subconscious biases, is to actually learn that green people are the same as yellow people. So it's something else happening there that I sentence them more. It's not that green people are more criminal. And we have, of course, this is common, is known that we arrest and sentence certain groups of people a lot more than others. And we also know from science that these group of people are just like all the other groups of people. There are no meaningful differences. So then simply by updating the knowledge that actually it's not that this group are less intelligent or more criminal, it's just that there is somehow so just understanding that they are equal makes you as a judge not subconsciously sentence them harshly. So if you, for instance, when you were hiring for the American Orchestra, for example, that we took as an example, if you didn't believe, so if you updated the knowledge to the reality that women are just as intelligent as men, or just as good players in music as men, then you wouldn't subconsciously select more men than women. So it's not knowledge that we are subconsciously biased, it's more the actual knowledge of the thing you're dealing with. So you need to update the actual knowledge. And that's why we need knowledge. That's why it's not enough to know that there are biases. You need to know, where does behavior come from? Where is it? So if you, for example, Jimmy is unpleasant, where does the unpleasantness come from? Where is it, what is it the product of? And once if one acts aggressively, where is it coming from? And once you know the formula of it, then you can, the subconscious will update accordingly, and then you will produce a different outcome from if you didn't have the knowledge. Does it make sense? So that's what is needed. Knowledge that explains how the reality is. Right? And then once you know the reality, decisions update.
Thank you very much. Mr. Selita for the response, lady. Is that okay? You got the message? Yeah, thank you. Now, okay, I see on the screen, somebody raise your hand. Pak Dr. Idewa Gede Palguna, he's our senior lecturer here at the School of Law and former justice or the former judge of the Indonesian Constitutional Court for 2 periods. I would like to invite you to deliver your questions or remarks directly, please.
Okay, thank you, Pak Budi. First, I would like to apologize because I cannot attend the seminar.
Moment, please, Pak Palguna. Suaranya bisa. Suara dari orang lain bisa masuk.
Can you hear my voice?
Okay, yeah.
Yeah.
Please.
Sorry for the inconvenience. First, I would like to apologize because I cannot attend the seminar offline because I have 2 classes to be fulfilled this morning. But I would like to ask Mr. Fatou Selita and maybe Professor, sorry, and also maybe Professor Kovas too. Just a simple question. I was wondering for so long whether which fund that has a very important impact in the purpose of building a law-abiding society, whether education or social environment in general, because sometimes I don't see any relation between education and law-abiding society. Maybe I'm too subjective in this context, but I would like to ask both of you whether if there any scientific evidence or scientific result of research that can explain the role of education into the building of law-abiding society. Thank you very much, Pak Budi.
Thank you very much, Bapak Dr. Idewa Gede Palguna. So the question is addressed to you. Please.
Okay, well, so complicated question, because the reason why it's complicated is because in behavior of a population, even in behavior of a person, there are multiple factors involved, far too many to even start mentioning. In behavior of a whole population, there will be similar, a myriad of factors as to leading to law-abiding or non-law-abiding society. And there are, for example, major players on this will be media. The media will be closely linked to large economical interests. So there will be far too, and of course international interests, what you're trying to achieve overall. So are you trying to make people, for example, more friendly or less friendly against a certain population, or more friendly or less friendly against a product, or more friendly or less friendly against a particular group or government or direction, and so there are far too many interests there involved that interfere significantly with education, and you would need to improve education quite significantly to enable people to protect from various influences like the media, etc., so that we take our decisions ourselves fully, as in decisions are purely ours, as it were, rather than influenced from far too many factors. And that will, I have been studying in this field now for too many years to even remember how many, and I don't think I'm protected from manipulations fully. So So to link education and law-abidedness, it's not, basically it's not, you can't possibly link them without considering all these other factors. Of course, education might lead to less law-abidedness if the law it's not in favor of the population. So if you have a law that actually is not in line with population's interest, then an intelligent population will be less law-abiding. They will actually be more likely to protest. And it's also as a known technique that the more knowledgeable the population, or the more educated, the more likely they will try to hold accountable those that are elected by that population. So I hope that gives some understanding on this.
Thank you very much, Mr. Fataselita. And now I'd like to invite Professor Julia Kovas.
Thank you. Yes, I know we're running out of time. I just want to say this is an excellent question. This is something I'm very interested in, and I know Fatos is very interested in. I think it's a deeper question. It's not just about relationship between education and like how law-abiding is society, but kind of more broadly, why cultures differ so much. And there are so many factors. For example, one theory is that all countries, all cultures can be split into kind of looser cultures and tighter cultures. Tight cultures are more collectivist, but also kind of more law-abiding. So people follow rules, respect laws, they are more dogmatic in a way. And there are theories that tighter cultures are partly developed because of various climatic and economic and other major forces. So, for example, if a country is exposed to a lot of tsunami or foreign invasions or food shortages and something like this historically, then maybe this culture can organize to become kind of very law enforcing, where people follow rules and laws because they have to in order to survive in a small space with a lot of people, for example. So there are many, many theories about cross-cultural differences, why cultures emerged. One theory is gene-culture co-evolution, how genes and cultures kind of influence each other, for example. And I think law-abidedness is just one element that we need to understand. And as Fatos said, education is only one part of this story. So a country with really high level of education can be really law-abiding or really not law-abiding, depending on all these other factors. So I think there is no simple question at all to this question, and it's kind of somewhat circular. But there is a lot of very interesting research in this, and I think maybe, I don't know how deep you're interested in it, but I would really like to have a conversation with you at some point. Thank you.
Thank you very much, Professor Julia Kovas. Bapak Dr. Palguna, I hope they have replied to your questions. Properly. Thank you very much. Now, this is the last, as I promised, and also the committee, we have some questions on the chat box of the WebEx, but allow me only to choose one. This is addressed to Pak Parikesit. Pak Parikesit, there is the questions from the participant, Professor Iputus Dharma Sumadi. Allow me to read it. I am interested to Pak Parikesit PhD, especially his parable about the applications, one general theory for every legal problem. The Steuvenbow theory from Kelsen first apply to business law problem. I asked the speaker, to you Pak Parikesit, how to guide the Kelsen theory, which has already become the theory of everything. Please, Pak Parikesit.
thanks for the opportunity, and thanks for Professor Sudarma Sumadi. Yeah, I try to answer this. Actually, this is a challenging question from my boss from Doctor of Law program, because my home base is in Doctor of Law program. And yeah, when we talk about the Hans Kelsen theory, and there is a trend that the theory, to some extent, forced to apply in business law. Yeah, maybe the answer, from my point of view, maybe little bit simplification. There is like the law of oversimplification from my point of view. When we analyze, for example, the business law problem, and we find any conflict of norm, for example, then we may just focus to understand how they are conflict. Of course, they conflict with higher, or in terms of hierarchy, conflict with higher laws. The focus should not only to explain, to explore how they conflict, but also why they are in conflict. And when we explore, the answer could be something beyond the law itself, something economic, for example, then we can use, for example, an economic analysis of law from Richard Posner to understand the trend, or something political that become the major driving force. This is, I think, little bit the matter of simplification. So the same like what happening in society, when we see people more successful than us, then we just say that, yes, they are success because they are genetically genius, or maybe because they just born in a silver spoon, or they just born rich, lekat di galungan, in Balinese people say, without going into the deeper analysis why they have been more successful than us. I think that's all my answer. Thanks for the opportunity.
Yeah. Thank you very much, Bapak Gusti Ngurah Pari Kesit Widateja, yeah, for responding to questions by the participant. So ladies and gentlemen, this is 12:15 on my laptop and my mobile phone. Yeah, I think we are going to conclude this seminar. Allow me to, just give us some notes that I can, this is not the concluding remarks, but just some notes. So I guess we all here agree that there is a relation, or even the very tight connection between law on one hand and other disciplines on the other hand. For example, with politics, economics, culture, environment, technology, psychology, and also genetics. Second of all, I guess all speakers support, at least there is no single objection from one of you, that interdisciplinary is a very relevant to be adapted into the legal studies. Yeah. In particular, to be incorporated into the legal educations. And lastly, it is undeniably that a future lawyer, yeah, needs to study law by applying interdisciplinary approach, yeah, to get the comprehensive overview, yeah. So this is not only about pedagogy, but also how to bridge the legal education and practice. Yeah. I think that's all. Thank you very much for your attentions. Thank you very much to all speakers, ya. Mr. Fato Selita, Profesor Yulia Kovas, Bapak Gusti Ngurah Parikesit Widya Teja, PhD, and Bapak Jai Maulana. Please give big applause to the 4 speakers, ya. And also, of course, to you, the participants, both at the online and offline. Thank you very much. Now, I'd like to invite the MC to continue that. Please.
Thank you, Pak Budi. Well, ladies and gentlemen, for now, we would like to invite all the speakers and moderator to the front stage, please, to the delivery of certificate and token of appreciation. And we would like to also invite the coordinator of Master of Law program, Bapak Dr. Bagiastra, to deliver the certificate accompanied by Bapak Dr. Pasa Wisanjaya as the head of the committee to deliver the token of appreciation and souvenirs. Thank you. Okay, let's take the photo, one more. Okay, 1, 2, 3. Yeah, one more pose. 1, 2, 3. Okay, thank you. You may all be seated. Well, ladies and gentlemen, finally we arrived at the end of our today's agenda. On behalf of the committee, we would like to say thank you for your participation, both for the offline participants and also for the online participants. For the link of the certificate, you can access it through the barcode and also the link available at your screen. And then thank you for your support and participation. See you at the next time. Thank you. Tambahan pengumuman kepada para peserta yang telah bergabung bersama kami secara offline di ruangan aula, kami dari panitia telah menyediakan hidangan santap siang berupa nasi kotak yang telah disiapkan di depan ruang aula. Terima kasih. For ladies and gentlemen, we already prepared